Thank you, Senators.
Thank you very much, Senators. Thank you.
And I'd now like to welcome representatives from RSL Australia and RSL New South Wales to the table. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you, and welcome. For the Hansard record, would you please state your full name and the capacity in which you appear today, and then I'll invite you to make a short opening statement.
Aziz Gregory Melick, National President of RSL Australia.
Thank you.
David James McCann, Board Member, RSL New South Wales.
Thank you so much. Would you like to make an opening statement?
Not specifically in relation to the short submission we've already made, which I think speaks for itself. At some stage, it may be appropriate to make some comments about this contentious matter of class or recognition for wounds. I can either do that now or under questioning, whatever suits.
I suspect we'll get to it in questioning, so perhaps we'll just jump straight into questions then if you're...
I have an opening statement.
Oh, sorry. Go ahead, Mr McCann.
Thank you. Chair and Senators, thank you for the opportunity to appear here today and speak on the submission by RSL New South Wales concerning Defence Honours and Awards System. I acknowledge our National President of the RSL, Mr Greg Melick AO, who is with me here today. You will note that the RSL New South Wales submission differs slightly in some respects from that of our national body. The focus of my evidence today relates to the long-standing concerns of our members on the administration of honours and awards by the Australian Defence Force, in particular recognition of historical service rendered to the nation. RSL New South Wales has a network of more than 310 sub-branches and over 30,000 members, representing a veteran cohort spanning several generations. For many years, our members have sought support from our organisation as they struggle to have their service they have rendered appropriately recognised. We acknowledge that Defence Honours and Awards have a difficult task to assess applications for recognition of individuals or veteran associations. It is recognised that there have been a number of inquiries held to improve the assessment process for historical honours and awards, but we believe the current process continues to place greater weight on the impact of recognition on potential veterans' entitlements provided by the Department of Veteran Affairs rather than the medallic recognition sought by veterans. There is also evidence that when considering historic applications for recognition, Defence Honours and Awards assessors tend to apply present-day criteria to these applications, despite such applications being supported by senior officers and first-hand knowledge of the circumstances of the service rendered. A number of examples where applications for honours and awards have been rejected despite seemingly sound supporting first-hand evidence from senior Australian Defence Force officers has been provided to RSL New South Wales, and include 4RAO service in the Malay Peninsula from 1966 to 1967 and No. 5 Squadron RAF service in the counter-terrorist role 1984 to 1989. There are many more examples and RSL New South Wales contends that there is an urgent need to review these applications and reconsider them. In a final report to the Royal Commission into Defence and Veteran Suicide acknowledged the significance of respect and recognition of service, and I quote, "While there is a lack of quantitative data on the respect and recognition wellbeing domain, it is an important issue for veterans. We have heard significant lived experience testimony from veterans in private sessions, in submissions and during hearings, and a lack of recognition for their service can significantly affect their overall wellbeing. The men and women of our Navy and Army and Air Force deserve the respect of every Australian for the unique sacrifices they make in the service of our nation. They also deserve a Defence Force honours and awards system that is consistent, fair and transparent when determining how that service is recognised. To ensure the integrity and efficiency of the Defence Honours and Awards system moving forward, RSL New South Wales seeks retrospective review, conduct a thorough review of all past award decisions, especially those relating to service before 1999, correct any oversights or inconsistencies. Historical criteria. When assessing awards, Defence Honours and Awards Tribunal should consider the criteria that existed at the time of service. This ensures fairness and acknowledges the unique challenges faced by earlier generations. Transparency. Improved transparency in the assessment process. provide clear guidelines for evaluating historical cases, emphasising the need to avoid present-day bias. Education and training, educate Defence Honours and Awards assessors, Defence Honours and Awards Tribunal members about historical context and the evolving nature of military service. Training should emphasise empathy and understanding. Thank you again for the opportunity to appear today.
Thank you both. I might just start with two brief questions, if I might, then I'll pass to my colleagues. Mr Melick, I noticed in your submission that you support the... So I'm just going to make sure I get the wording right here. You support the change in criteria that I think happened in 2011 from to extend to in warlike operations rather than in action, because we have heard from some who appeared earlier today they believe that was has led to a distortion of the award system since. But I wanted to get your opinion, professional opinion on that.
Well, it's consistent with historical awards. The Distinguished Service Order is a classic example in World War I, World War II. It was either awarded for under fire or in combat operations or a distinguished service. You had parallels. You could go into a warlike zone and you could get an Order of the British Empire or a Distinguished Service Order, which could either be for under combat or not under combat conditions. And historically, the change in the conditions aligns historically with what used to happen before. In other words, if you're a distinguished leader in a warlike situation but not actually involved in combat, there's no reason why you shouldn't be eligible for such an award.
Okay, thank you. I just, you might have heard the witnesses previously, the Australian Special Forces Alliance just provide evidence about the award of honours to the commanders of Joint Task Force 633. They note that I think nearly every commander who served over 6 months over 14 years received either the DSC or a similar award or an Order of Australia.
Every battalion commander of Vietnam got a DSO.
Okay, so that's...
I'm not saying it's correct. It's
okay,
what should happen.
I'm asking from your experience, is that unusual or there is precedent for it?
It seems to have been forever thus.
Okay, thank you. And Mr McMahon, just one question. In your submission you refer to the composition of the Defence Honours and Awards Appeals Tribunal, and you make a suggestion that you believe there should be an additional member appointed, or it's weighted slightly too heavily to former ADF personnel at the moment, the composition?
Yeah, that's correct, Senator. As perhaps we heard in the last volley of evidence, the tribunal is quite eminent in its composition at the moment, but we do feel that there is room for lay membership that may be somewhat divorced from the defence system that can cast a community view on what's being assessed by or asked for by the veteran.
All right. Thank you so much. Senator Roberts, did you have some questions?
Thank you, Chair, and thank you both for appearing, and thank you for your service. I'm going to ask a question that I asked of an earlier witness. You've mentioned long-standing concerns going back before 1999, and some of the other conflicts would be probably 20 years before that. So that's this has been a concern for a long time. Is there a stigma about speaking up about medals? A lot of the personnel are very humble people, and I've had the pleasure of getting to know Special Forces veterans, for example, and other members of the Armed Forces who've done the most extraordinary things, but they won't raise it. They won't brag, and if I ask it, they'll happily tell me. When these people are denied rightful recognition of the correct medal, there's a hesitation to speak up about it. Why is that?
I think, Senator, from an RSL New South Wales perspective, we obtain our information directly from the veterans who either propose motions to us through our Congress system when we meet together, or write to RSL New South Wales separately. But the underlying factor is that they are concerned about having their service recognised. They're not after the glory side of it. It's just simply that they believe they have rendered service that warrants the award of medals that have been denied to them. And in fairness to the current system and previous systems, We accept that there are cases where individuals believe they should be recognised, and there simply is no case. Our submission and our argument goes to those veterans and groups of veterans who genuinely have evidence to support their belief that they're entitled to medallic recognition, but are denied through the current process.
Thank you. I was writing something when you mentioned, if you could explain now what you're talking about. There are two aspects: veterans' entitlements and some separately awards.
Well, I suspect there's a concern amongst the veteran community, particularly our members, that when assessing historical applications, there's greater weight placed on approval of that recognition could bring with it entitlements under the Veterans Affairs Acts. And I contend that is not the case. The veterans normally in the cohort that I'm talking about, in particular for RAR and its service in Malaya in 1966, most of those veterans would have most likely gone on to Vietnam following that service in Malaya. And they're not seeking further veteran entitlements, they're seeking medallic recognition for that service.
But there's a fear in the bureaucracy that that's not the case.
That's correct, Senator. Yes.
Okay, now I get it. Okay. You also mentioned long-standing rejection of sound recommendations, and you're still pursuing some from decades ago.
Absolutely. Again, if I can refer to the two cases I mentioned in my opening statement, that of 4RAR in Malaya and 5 Squadron RAAF, both applications for medallic review.
What years was that?
Sorry?
What years was that?
1984 to 1989. Both of those applications contain significant supporting documentation from senior officers directly involved in that service, but that didn't appear to carry much weight in the tribunal's assessment process. And we contend that first-hand experience, the lived experience, and particularly if it's supported by senior officers who can testify to the circumstances that existed at the time of service, that should carry more weight in the consideration.
So why is it ignored or downplayed?
I can't comment, Senator, I don't know.
Because we're hearing similar things today about enlisted men.
Yeah, I don't know the answer to that, Senator.
Can we go into some of your New South Wales submission, potential improvements? You talk about composition of the tribunal members. Could you explain that, please?
Well, as I mentioned before, Senator, yeah, we believe there's an opportunity for lay members, perhaps members somewhat distanced from the defence system, that can look at these historic applications through fresh eyes. That's not to criticise the current tribunal, and we acknowledge the experience and that they bring to the table, but we believe there's room in that process for external review.
So you're seeking objectivity or impartiality?
Yes.
Would there be a lack of understanding of what goes on in a war zone?
Not so much lack of understanding on what goes on in the war zone. I would contend that a lot of these applications that are rejected are based on dates that have been arbitrarily assigned to when service began and finished. And whilst I understand and acknowledge completely that we need a system that makes awards for services rendered over a certain period, the actual facts of the matter are that service doesn't necessarily end on the day that an article is signed in Canberra. And a number of the representations from 4RAR members in relation to their service clearly indicate that operations continued on after the cessation of hostilities in that operation.
So, my last question, Chair. Oops, he's gone. What are the most important issues you'd like to see explored and hopefully resolved by this inquiry into the award system?
I think I would like to see a review of those applications that have been put forward for determination by associations representing groups of veterans. I appreciate that individuals also put in such applications, and it may be unwieldy to suggest that should happen, but I think there is a need for a review of those historic applications with the view to a more liberal consideration of the circumstances.
So the recognition is really very important. Every witness so far has confirmed that because people have given years of their life and risked their life many times.
Absolutely, Senator. As I said in my opening statement, veterans aren't seeking financial remuneration or veterans' entitlements for their service. Medallic recognition is a tangible way of saying that they serve the nation. It's a tangible asset to be able to pass down to the next generation of their family. And in the older cohort of veterans, particularly those veterans, as I mentioned, from 4RAR, there are only nearly 40 or so of them left. So they're not after a big payout, they're simply after recognition of that service.
It goes to the heart, not the wallet.
He's got a friend calling. Hello. On that note, thanks very much, Senator Roberts. We need to keep moving the call around, so we're going to hand the call over to Senator Fawcett. Senator Fawcett, you have the call.
Thank you, gentlemen. Thank you for your submissions and for being here today and for your service. Can I just pick up on one point Senator Roberts was talking to you about? I understand, you can clarify if I'm wrong, you don't agree with some of the previous submissions that the change from inaction to warlike service is necessarily an aberration from past practice, nor is it the root cause of some of the current issues. Am I correct in understanding that?
Sorry, Senator, you're addressing me?
Yes.
No, our position is this. It's not inappropriate for an award such as DSC, which really took over from the DSO, to be awarded to somebody not actually engaged in combat but serving in warlike conditions. So we don't think that's an aberration. We don't suggest that's an aberration. We think it's an appropriate amendment.
So I'm not aware. I know the tribunal has made it very clear in terms of what inaction is. In terms of warlike conditions, are you aware of a definition of that? Because a lot of the criticism appears to be that warlike conditions would assume that you are personally exposed to some risk as opposed to being in an adjacent country or some other location. So how is that defined? And does it, in your view, does it matter? Because it clearly does to many other submitters.
It's not defined. It's always difficult to define. It's a question of going back to what you think the purpose of the award is. If you're an officer who commands a group, who trains that group, takes them away to war, and the group performs extremely well, we say that's not necessary. It's not inappropriate for you to receive an award recognising that. It's a question of what award it is, and under the current system we have the DSC, the DSM, and could possibly be done under an Order of Australia, although it doesn't seem to be the way in which it works at the moment. Combat-related things seem to always be the DSC, DSM line. As I said before, in World War II they had two parallel streams, civil and military, which often crossed over. In fact, ironically, I had an old friend who was recommended for an MC and in action, and they gave him an MBE, which he was upset about because he would rather have the MC. And then he got a DSO for a staff job. So it's sort of cancelled out as far as exposure is concerned. But that's for others to argue what warlike circumstances should be. Our view is there should be appropriate recognition for a commander who trains a group of people, takes away and performs a task in an appropriate or exemplary manner.
Sure. So a previous witness highlighted the proposal that Mike Kelly put forward when he was a Parliamentary Secretary for a recognition of command and leadership, but where the commander was not actually in action themselves. Do you believe there's any merit to that approach? Do you think that would resolve some of this disquiet between differentiating decisions that are made when in action and under threat yourself versus that broader command, preparation, deployment, strategic oversight?
I wouldn't support that. I think you then have a problem you'll have commanders probably wanting to go into the warlike zone or into action just to get the tick in the box, when it'd be more appropriate they sit back and control what's going on within the field. My view is a commander should be properly recognised. Sorry, it's not inappropriate to recognise a commander who performs well, whether or not he's in the actual front line or sitting behind it directing troops.
Okay. One of the other topics that has come up today is recognition for people who have been wounded in action, and by extension, families that if they then lose their life also have that medallic recognition. So think the Purple Heart sort of system the Americans have. Does the RSL have a position on that?
The question becomes, you talk about physical wounds or mental wounds,
Physical
and to
is what's
what
been
extent?
talked about.
Sorry?
Physical is what's been talked about.
Well, I'll put some rhetorical questions. If you have a soldier like in World War I who was buried by an artillery blast, is dug out and has no injuries, but he carries horrific scars for the rest of his life mentally, has he not suffered as much, if not more, than somebody who's received a flesh wound? So why should you distinguish between physical wounds and mental wounds? And I know a lot of service personnel think there should be a distinction, and a lot think there shouldn't be. I think when you start talking about recognition of wounds, you open up Pandora's box. I mean, the Germans in their Teutonic thoroughness had a system with World War II where you had either a black, silver or gold wound badge, depending on the number of times you were wounded. 1 to 2 for black, I think, 3 to 4 for silver, and 5 and above for gold. But that was defined, as I understand it, by physical wounds, no mental wounds. And if you're going to bring in a system just for physical wounds, do you get an extra bar or extra class each time you're wounded? And then what happens when you run out of room on your medal bar? Our preference is no recognition for wounds because we think it creates more problems than it solves.
Mm-hmm. My understanding, and advocates for that may wish to correct me or speak with you afterwards, but my understanding is it's not so much a request for how many times have you been wounded, but the fact that there has been a significant life-changing impact for the person and their family because of their service, and a recognition for that. But I'll leave that perhaps to others to confirm or deny that definition.
Well, as I said, if you just restrict it to physical, what about the people who suffer the mental injuries who probably suffer more?
I hear that.
And so, if from our position, we're going to have it to be one in all in, and yet a lot of our members, a lot of service people, would like to see a distinction between physical and mental wounds.
Sure.
So I just think there's a lot more work to be done on this.
So can I come back to process moving forward? There's been a number of submissions that have highlighted that people have made a recommendation for a commendation for gallantry, for example, which then the command chain, various steps, have either altered the level of the award or even the actual stream of the award without the knowledge of the recommender. So by the time it gets to the decision body, they're not actually dealing with the original facts and there's no feedback loop there. Does the RSL have a view as to whether we should continue with the fact that the recommender should be a witness to the Act or the service, or the command chain, either through observation or in post-action reports, etc., but that the original recommendation should be visible at every point of any review and decision chain, so the final decision-making body know what was originally recommended and can understand and challenge or question any subsequent notes, amendments, suggestions for a change.
The RSL hasn't specifically considered it, but I can offer my personal experiences and opinions. I'm very much against the decision of an original recommender being overturned without being referred back to them to answer the concerns of the people looking at it. I've had experience where I've put up people for various levels as a brigade commander, and the orders have been completely reversed without any consultation back to me. I know it was probably done by reasons of sex and all the rest of it, but when you put up somebody for an OAM and somebody else for a commendation, and the person you put up for a commendation gets a CSC and the other person gets nothing, or a commendation without reference back, you get concerned about those sort of things. I think we should be more concerned about educating commanders to make sure they put up balanced recommendations across the field rather than overturning commanders' decisions without consultation back to them.
So one of the former witnesses used the example of a judge having to give a statement of reasons. Would you support a requirement that where something is rejected, that essentially a statement of reasons comes back to the recommender or the command chain?
Yes, I don't know if it have to be a statement of reasons, rather it could be just a conversation, or look, you've recommended so-and-so, we have concerns because of A, B and C, what do you say about it? But I think there should be a referring back to the original proposer before their decision's overruled, especially when you have that person puts up a group of people and you change the weighting or order of the preferences, because the best person is the person on the ground who's involved in the actual incident or overseeing the incident.
Sure. Okay, thanks, Jim.
Thank you, Senator. And in the interest of time, I think we will move on, but thank you both for your appearance today, your submission and your continued service on behalf of the veterans community as well.
Thank you.
Now, we'd now like to welcome representatives from the Australian Special Air Service Association. Appearing in person, yep.